Minority shareholdings are often seen as low-risk strategic plays, a way to build partnerships or explore future M&A. But the European Commission's latest €320 million fine tells a very different story. In this Compliance Compass episode, I'm joined by my partner Natalia Schuster in our corporate team to break down why a 15% stake triggered cartel penalties and what your business should do differently.
In 2018, Delivery Hero, a food delivery company, acquired a minority non-controlling 15% stake in competitor Glovo. Over the next 4 years, until it acquired full control in 2022, the Commission found that the two companies agreed not to poach each other's employees, shared competitively sensitive information, and coordinated market strategies and effectively allocated markets across the EU, removing geographic overlaps. The Commission concluded that the minority stake itself enabled these anti-competitive contacts.
What makes this case different? Well, several factors. First, it's the Commission's first standalone no-poach cartel decision, a clear signal that labour market conduct is now firmly on the enforcement radar. Second, and just as important, it's a landmark ruling on minority shareholdings. While the Commission reiterated that owning a stake in a competitor is not itself illegal, it drew a firm line. If that stake gives you access to sensitive information or influence over strategic decisions, you are not protected.
Yes, we generally tend to think of minority investments as pretty low risk. They can be an excellent way of building or strengthening strategic relationships, or as you said, preparing for a future full acquisition. In this case, the legal rights that Delivery Hero negotiated as part of their minority investment allowed them access to Glovo's internal documents and visibility into Glovo's strategy. The rights were pretty standard: board nomination rights and voting rights. According to the Commission, this allowed the two companies to align market behavior. That's what gave rise to the legal risk. And with cross-ownership increasingly common in sectors like tech, energy, life sciences and infrastructure, this isn't a one-off risk. It's structural and it's spreading. Large companies, especially in the tech sector, now also run large venture capital divisions and participate in multiple investment rounds, including of potential competitors. And the situation will always be challenging for the investor. On the one hand, they need enough information and investor rights to protect their investment. On the other, they need to balance that against the legal risk of falling foul of competition law rules.
So how can you protect your business? Well, review shareholder and JV agreements, especially for no-poach, exclusivity, or information sharing clauses. Scrutinise board rights and reporting lines. Could a minority investor get access to competitively sensitive information? Don't assume non-controlling means you are exempt from scrutiny. The position is different if you have sole control, as that comes with intra-group protections, but until then, competition law fully applies. And have clear internal protocols for how strategic alignment, data sharing, and personnel decisions are handled between linked entities.
We work with clients to identify and manage these hidden risks at every stage of the investment life cycle, from structuring and governance through to compliance reviews and regulatory engagement. If you're holding or planning a minority investment in a competitor, remember it can create real risks. But there are strategies to mitigate these risks. Just like we use clean teams in M&A transactions, it may help to nominate trusted but not directly connected representatives to the most sensitive boards and committees of investee companies. Documentation is also key. Investors and investee companies should ensure they are in a position to show exactly how and why decisions were made and how information flow was managed. Careful structuring and oversight are now more important than ever, as the signal is clear. It is very much on the Commission's enforcement radar, and we shouldn't assume that minor stake means minor scrutiny. This is the time to review existing arrangements and make tweaks where necessary to minimize risks.